playing golf on that day. And the jury, which otherwise would have had the case on Friday, now has to return on Monday. He comes on Monday and he testifies. Are you saying the judge is not able to impose any appropriate sanctions against that psychiatrist for failing to show up as promised on a particular day?
We've never said that.
Okay, so what's the judge supposed to do then?
I think the judge should hold a contempt hearing.
Well, it's not contempt.
Well,
There's no order of the court that he's supposed to appear.
If there is an order of the court, if there's no order of the court, it still interferes with and delays significantly the business of the court, where certainly hearing can be held and she can sanction that individual after.
Okay, and isn't that what basically? I mean, I gather that he was invited to prepare an affidavit in this case, and he chose not to. He chose not to do an affidavit.
Well,
and she sanctioned him.
But well, no, she sanctioned him, and then she invited him to file an affidavit. But I'm not his attorney, but it seems to me he had no incentive to file an affidavit at that point because, as we've represented in the brief, he'd already been paid in full.
Right, but he's still continuing now as he appears in court again. He appears in court every week. The court is powerless to say, you owe me $120, I'm going to take it out of the next payment? That's what she did, basically.
No, I think what she had the power to do and what the chief counsel told her she had the power to do, both in his letter in August of 2006 and before her in a hearing, was not to use CPCS as the arrow in the target, but to use whatever repertoire of inherent power she had as a judge to express her displeasure directly to the witness and to sanction the witness if so warranted. What we took issue with was the order to us.
She could have fined the witness.
She could have fined the witness.
And then she could have entered an order, and then if the witness didn't pay, and which would go into...
Our position has always been what's dangerous is to use the agency as the instrumentality to express displeasure to a witness, not that there may not be circumstances.
It's not expressing displeasure. She already has expressed displeasure. It's to collect upon an unpaid sanction, essentially.
Well, then she issues an order, and...
I mean, it certainly was complicated by the fact that by the time the order came out, the bill had been paid in full, and there wasn't an order, at least at that point, to CPCS to recoup that.
Right. It's not. No one
overpayment.
says CPCS. At least I'm not saying CPCS was at fault. But you have Dr. Plowd, who was supposed to pay $120, and he didn't. And he's appearing in court every month, and he's being paid by the court. And the court can't say you owe us $120 instead of paying you $10,000. We're going to pay you $9,880 and take our $120 back that way.
Yes, that's our position. The court cannot do that. If there are no other questions, I'll rest on the brief.
Thank you, Ms. Eisen.
Thank you very much.
SJC-10297, Board of Registration in Medicine versus Hallmark Health Corporation.
Good morning, Ms. Miller.
Good morning, Your Honors. Jennifer Grace Miller from the Attorney General's Office, here today on behalf of the Board of Registration in Medicine. Your Honors, the legislature has explicitly authorized the Board's access to the peer review materials that it seeks here today.
Ms. Miller, is this case answered in your favor by footnote 21 in Carr versus Howard, where Justice Freed wrote, moreover, Section 205B specifically grants the board access to such materials, and such materials are talking about incident reports that would have otherwise been privileged.
Yes, Your Honor, certainly that footnote is very strong support for our position today. It could be argued that this Court has not faced this precise question as to whether or not the board has to wait until after it has filed a formal adjudicatory proceeding. That hasn't been faced directly by the court in this context with respect to 205.
But, if it does, then if it has to wait until after proceeding is begun, then it doesn't make sense because you already have that in 204, so why do you need it in 205B?
Certainly, that would be our
That's
argument,
your
Your Honor,
argument.
that this
But
is
let me
really...
ask you this question. Are you seeking everything, or are you seeking everything except core materials?
We are seeking everything but core materials. We are
Okay,
not-
and why do you think, if you take the position that we just discussed, given the two sections of the statute, why are core materials exempt? Still protected?
Right. Well, because
Because
Beth
it's
Israel said that they were exempt.
Okay, okay.
You know, if you
What,
read the...
what comprises core materials?
Well, Your Honor, a handy shorthand was provided by this court in Vrenos, also in a footnote where they cited the appeals court in Miller. And the handy shorthand, if you will, is that the materials have to be created by, for, or as a result of a peer review committee. Now, that's all the protection. That's 204 and 205. And the way we think it breaks down is that by, materials created by the board are the work product, and they are protected by 204. The other materials, the materials created for the peer review committee or as a result of the peer review committee, those materials are less central, less core, and are therefore protected by 205, Your Honor. So by, for, or as a result of.
So what you say is protected by 204 is only the work product in the sense of the actual production of a peer review committee.
Certainly testimony before a peer review committee, certainly the reports of that committee, certainly the minutes of that committee, anything generated by the committee itself.
Wait a minute. So testimony before?
I think you have to read 204
Yeah.
to include that, Your Honor, certainly.
Okay.
So actually,
So this is a peer review committee doing, because here, I take it Hallmark identifies the three that play a role in credentialing as peer review committees, right?
right,
But
and
when you're using it in the 204 sense, it's peer review committees conducting an investigation, not credentialing? I mean,
no, it has to be a peer review committee within the terms of the statute. Now, of course, it wasn't challenged below as to whether or not these three separate committees are actually peer review committees within the statute. But as long as they are, then their work is protected, Your Honor.
okay. But things given to them, you would say, aren't protected.
If they're they're not protected under 204. They
Right,
are
no, they may be
protected under
protected by
205.
205, but you would say, therefore, we have a right to subpoena them.
Exactly. Things like the application, for example, that Dr. Doe submitted to the credentialing committee. That document was created for the committee. They knew we were going to review the application in order to extend him privileges or renew his privileges. Therefore, that document was created for the committee.
Now, pragmatically, let's assume you have an allegation that Dr. Doe is never received a medical degree, or that there was some incident in Montana where he served, and you wish to investigate it. And let's assume this case goes differently, goes in favor of Hallmark. How do you go about doing that investigation without having access to these materials?
Obviously, it's a lot harder, Your Honor, and I think that's part of what the legislature recognized in allowing the board access to these less core materials. We would have to, first of all, discover the sources of these materials. We wouldn't necessarily, we should know where he went to medical school because that's part of the licensing process. But if there are other third parties that the information would be relevant, and we don't know who they are, but the hospital does, then we wouldn't have access to that information initially. And you're talking about incidents that happen in Montana or elsewhere. We would obviously have to go to Montana. We would have to go and investigate those situations and expend the limited resources of the board in order to conduct that investigation.
And if you were to lose here, I gather that if he were on his application to lie and to provide false credentials, you wouldn't know about that until you commenced an adjudicatory proceeding against him.
Correct. This is a perfect example, Your Honor.
And then how could you begin the proceeding? You might not have enough information.
We might not have
Catch
enough
22.
information. That's obviously one of the dangers that I think the legislature was looking to avoid. When we issue a statement of allegations, which is the formal commencement of the proceeding, obviously the board and everyone else, truthfully, has an interest in that statement of allegations being as complete and accurate as humanly possible. And it may very well be, if we don't have access to certain materials, we may not be able to bring an adversary proceeding.
So where did the trial judge go wrong? I'm looking at his memorandum, and he started with the inquiry turns on the way to which the document was created and the purpose for which it was used, not on its contents. In other words, the principal focus of the inquiry is on whether the document was created by, for, or otherwise as a result of a medical peer review committee. And then he looks at each one of those questions, by, for, or as a result of the peer review, and he concludes that it was for peer review. And obviously you argue a different conclusion.
Right.
Where did he make a mistake?
Well, I think he made two mistakes, Your Honor. The first mistake he made was in not recognizing this distinction between the protections of 204 and 205. Now, with regard to the general public, there is no distinction between 204 and 205. If the documents are protected under those two statutes, then the members of the general public do not have access to them. However, 205, very specifically in the language of the statute, gives the board access to these less core materials under 205.
So that would be the for or as a result of.
Exactly right, Your Honor.
And I take it, if you look at the legislative history here, credentialing is very different from peer review,
Exactly.
right? I mean, the function that the hospital is performing in credentialing is different from the function that the hospital is performing for peer review.
I think that's right, especially when you're talking about sort of classic peer review things like reviewing an incident at the hospital. Credentialing is really about risk management. Credentialing is really about making sure that the folks you have working for
Well,
you.
they're both about risk management. so
They
be
are, Your
careful.
Honor.
They're both about risk management.
You're right, Your
Right.
Honor. But this is
The one is a forward-looking risk management, and the one is backward-looking risk
or
management.
preventative, if you will, risk management in the case of
For
credentialing.
forward-looking risk management, the presumption, I would assume, is that there's no reason for people to feel afraid about disclosing whatever they disclose.
Right.
Backward-looking risk management is fraught with difficulties.
It is fraught with difficulty, which is why it is entitled to greater protection.
Can I ask you a question? I know that amici cite various reports of the general counsel for the board, and it's a little confusing to me because you've got all these different names, the peer review committee working under different names.
Right.
So I'm not sure how this applies. But the board taking the position that the information you're talking about now, as best I can tell, is not shared with the board's enforcement division.
Right.
As a matter of policy.
Sure. And I should note initially that it is a matter of policy. It's not in a regulation. It's not in a statute. It's a practice of the board. And essentially, Your Honors, the legislature has given the board certain powers, including these powers to access these 205 materials at the investigatory stage. Then the board chooses how to exercise those powers in its discretion in order to effectuate its various functions. There are several functions of the board. One of those functions is the patient care assessment unit. These are the folks who implement the patient care assessment program. And another function is the disciplinary unit. They do entirely different things.
At the board.
Exactly, at the board. They do entirely different things. The PCA unit monitors essentially the entire system for patient quality of care and to make sure that the system is working appropriately in order to ensure that care. Obviously, the disciplinary unit has a more limited function. It investigates and prosecutes disciplinary actions against individual physicians. So the board, in exercising its discretion, has to decide how to use its powers most effectively. With respect to the information that goes to the PCA unit, all of that information comes into the PCA unit and doesn't go anywhere else. The idea behind this is that it's to give some assurance to the healthcare providers that essentially the disciplinary unit is not trolling through the data that's being collected by the PCA unit and looking for disciplinary actions.
So in this case, it could be that the PCA, I mean, this is the disciplinary unit seeking it, because it's, but the PCA unit could already have it. Is that
Theoretically, yes, Your Honor. Theoretically. And we don't know, so.
Right.
The board then exercises parts of the disciplinary unit in order to effectuate its purposes, operates by subpoena. When they're looking for information, they subpoena it. It has the benefit to the hospitals, if you will, of the hospitals knowing
Being put on notice.
exactly, precisely what the inquiry is. And I would imagine that the hospitals would consider that a fair way of proceeding, rather than keeping the matter cloaked in secrecy.
Now, why would you have to subpoena this? There's nothing in 205 that says that the disciplinary unit has to subpoena this.
It doesn't say that we have to subpoena it, Your Honor, but we choose to subpoena it.
Because it gives a forum to challenge it if you want.
Exactly right, Your Honor, because if either the hospital wishes to challenge the board's request, or the board is looking for the enforcement powers of the court to actually get the materials it's entitled to, it certainly makes sense to have it in that form, if voluntary compliance doesn't work in the first instance. And I want to just quickly return to Justice Ireland's point, asking about what the mistakes of the Superior Court were, and there were two. And I think the first was, as we've been discussing, this issue of whether or not the Superior Court recognized this critical distinction that appears to be on the face of the statute, because as Justice Cowen notes, it wouldn't make terribly much sense to have 204 and then have 205 and the specific proviso in 205 if you weren't looking to make a difference and a contrast from 204.
And the proviso in 205, sorry, I just...
The proviso in 205, first, the statute first describes these other materials that are going to be accorded peer review status, and then it literally says, provided, however, that these materials may be inspected, maintained, or utilized by the Board of Registration in Medicine, including, but not limited to, its disciplinary unit. So to the extent that Hallmark is arguing that this statute only gives the board access to these materials as part of its quality management function, the express terms of the statute gives a lie to that, because there would be no need to reference the disciplinary unit if the board's access to these materials were going to be so limited. But I did want to return to the second issue. The second issue is that the judge below did not perform a careful enough review. This question, this three-pronged question of for, by, for, as a result of, with respect to each and every document. So I think, regardless of how this court sets the rule.
You mean based on the privilege log, is that what you're saying?
Exactly. That regardless of how this court sets the rule, the case will have to be remanded for a more careful look at each and every one of these documents. Because certainly if the case goes our way, then the Superior Court has not made this distinction between documents that were for the board and documents.
You're not suggesting, are you, an in-camera review, or are you?
No, certainly not. That's been made very clear.
Right.
That
So it's just based on the privilege log.
on the privilege log and on the additional information that the parties provide, not the documents. Exactly right. But there will have to be a more careful review.
From your point of view, Ms. Miller, is the privilege log adequate to make that determination?
Well, certainly the Superior Court didn't find it initially adequate to make that determination.
No, I understand. I'm talking about now.
I think the privilege log as it stands right now does not include enough detail for the judge to make the decision on the face of the privilege log.
So let's assume that, assuming that we were to agree with you, part of what counsel in the future would understand is you have to distinguish among documents that fall under 204, 205.
Correct. You have to make it very clear for the trial judge which privilege you're actually asserting.
And in terms of this clarity, it sounds as if what you're saying, and correct me if I'm wrong, is that you would draw the line that what the peer review committee said or wrote, or reports written at its direction, are core.
Correct.
And nothing else is.
And nothing else is. Everything else is important and related, but not core.
But you included testimony.
Yes, Your Honor.
Okay. It may not be relevant here, but the provision in 204A that says, exempt from disclosure except proceedings held by the boards of legislation. Just help me.
Right, well, Your Honor, the Beth Israel Court and the Choate Sims Court
Right.
have already decided that even though there might be some ambiguity in that language, that the board is nonetheless not entitled to those documents unless and until it actually commences a formal proceeding. The court has focused on the words proceeding.
Discovery.
Right.
So
That's-
okay. Thank you, Ms.
Thank you,
Miller.
Your Honors.
Ms. Eldridge?
Good morning, Honorable Justices.
Morning.
What the board is proposing to this court is basically to make the peer review committees and the QCAP processes at Hallmark Health part of the investigatory arm of the board. This is specifically what this court and the legislature, in fact, did not intend to happen.
Do you see a difference between 204 and 205?
205 specifically says in its introductory paragraph that all of 204 is incorporated into 205.
So your answer is no, they should be treated the same.
They are treated the same.
So what do you say about that proviso, provided, however, that such information and records so designated by the Patient Care Assessment Coordinator may be inspected, maintained, and utilized by the Board of Registration in Medicine?
We have an introductory paragraph to that, which presumably the legislature intended to have some meaning. It's incorporated 204, which says that the board, at least in the enforcement division, cannot get that information investigating a patient complaint until such time as the 30A proceeding has been initiated.
But you're reading out an entire set of sentences in 205. There's one right after the proviso that says, however, the records may not remain confidential if disclosed in an adjudicatory proceeding of the Board of Registration in Medicine, which seems to imply that the board has access to them. They have to hold them confidential, and those records will remain confidential until such time as an adjudicatory proceeding commences. So that built right into this statute, the board has its hands on some of these records.
I would respectfully disagree.
What do those words mean?
You
At
mean
what?
access, that they become access to the public.
I think just before the Beth Israel decision, the legislature started to address the issue that a lot of the material that comes under the board's risk management program, the risk management program specifically includes credentialing, might be exposed, and that was a concern in the BI decision, because it was not specifically peer review under 204.
Well, why can the data repository unit of the board get access to certain materials under Section 205? I take it presumably to make sure that the hospitals are properly managing, at least numerically, are properly managing their risk management cases.
Actually, the Patient Care Assessment Committee of the board, the one that we've submitted the comments from, is a division that oversees the Patient Care Assessment Plan, the QCAP program, that involves the credentialing and the incident reports that are done under the board's risk management program under 112, Section 5. I would submit to you that what the first sentence of paragraph B is saying in 205 is that all of the privileges of 204 are incorporated into information and records that are necessary to comply with risk management.
Hold on,
And
I'm sorry, Ms. Eldridge. I've got 205 here. Just where are you reading from?
the first in Section B, Your Honor, it says
Section
information.
B for boy?
B for boy, Your Honor. Information and records which are necessary to comply with risk management and quality assurance programs established by the board, which includes credentialing under the board's own policies, and are necessary to the work product, including incident reports, including materials
Yes, but you get them under 204 for purposes of the public, but that proviso puts the board in a different position, doesn't it?
No, Your Honor. I think what happens is, if under the first provision of paragraph B, if they have to have a 30A proceeding initiated in order to do it, what the next provided that sentence it makes clear is that once the board has access to the materials when a 30A proceeding has been initiated, then the board can utilize that information, but it can't be obtained by outside people. It's no longer it's not available to the public.
Well, of course, if they have it, they can use it. I mean, you don't need to be told that, right?
Well, I think you do, because I think that was one of the issues that led to the enactment of Section 205, was the concern that the materials once at the board, such as incident reports, et cetera, were no longer protected by the peer review
of course,
privilege.
we're no longer protected what?
We're no longer protected by the peer review privilege. Once the board had their hands
You
on
mean
it.
from the public?
The public, yes.
Right. So we've got two different issues going on here, right? We've got a FOIA request, a Freedom of Information request, right? And so 204 makes clear can't get access to them, right? Now the legislature is saying you can give these for risk management and quality assurance, and it wants to make sure that if the board has them, they're not protected from the public. They're still protected from the public, correct?
They want to make, once they're in the hands of the board, that they're still protected from any other source that might be looking for them. It might be a plaintiff, it might be anyone who is
I
trying to get
understand.
the information.
The public.
That's correct, Your Honor. But there's no sense to the initial introduction on the information and records that are necessary to comply with the risk management programs. There's no reason for that sentence to be there if the legislature didn't presume that, intend that they could only get them once the Section 30A proceeding had been initiated.
Why? Why is there no reason for them to be there? Because it's protecting it from the public, but not necessarily from the board.
I would think if the legislature had wanted the board to have free access to it, it would not have enacted that first sentence. It could simply have said that information and records that are necessary to comply with the risk management programs may be utilized by the Board of Registration, including but not limited to its data repository. But as to everybody else, the Section 204 privilege applies.
Yeah, but all it does is essentially impose the same rule of confidentiality on the board as it does the risk management committee or any repository of this information. The board cannot disclose this information to the public until such time as an adjudicatory proceeding starts. You're putting the board in an untenable position of starting an adjudicatory proceeding against a doctor with little or no information in order to proceed.
I would disagree that the board has little or no information. The board has available to any query information it may want to get. It has access to the National Practitioner Data Bank. It has access, actually, to the same information the peer review committee would have in terms of its ability to do interviews, to get medical records, to get copies of policies and procedures, much as the plaintiff, in the face of the peer review statute, has the same right. The only thing that is not available to it are the actual documents. The board can question the physician.
Ms. Eldridge, with respect to the statutory history, I mean, I understand the import of, that the board has these two separate functions. Is there anything to suggest that the legislature was focused at the time of the enactment of 205 on the different functions of the board?
It is the Risk Management Board Division under Section 112, Section 5, that has the right to run this program. I think this Court's decision in Carr indicates that the legislature did have some concern about who would be access the right of the...
It would be very helpful to me if every time you said the legislature had concern, if you didn't think about the rest of the world, plaintiffs, newspaper people, just the other side of the board. Okay, so is there anything in the legislative history that suggests that the legislature was concerned that in giving access to these records to the risk management and quality assurance side of the board, it did not want to give the same information to the disciplinary side of the board?
Yes, I think there is not much, quite frankly, Your Honor, in terms of legislative history on Section 205. It did come into being right after, within days of the Beth Israel decision. And the Beth Israel decision really spoke to the Patient Care Assessment Division, the Risk Management Division of the board, getting its hands on the incident reports and such, because under the board's own regulations, it was the Risk Management Division was the division that was entitled to get the quarterly reports on incident reports, major incident reports, and that type of information.
Let me ask you the question that I asked Ms. Miller. The function of risk management, quality assurance, credentialing, is really somewhat different from the function of peer review. And you're shaking your head. You say no, it's all the same thing.
I would say no, Your Honor. If you're going to be credentialing your physicians, you're looking to see how they're doing. You're concerned about the quality of care. I think the process within Hallmark is fairly well described in the affidavits and the supplementary material and the deposition of Dr. Summerer. You are looking at specific instances. They're looking at the quality of care through incident reports. They gather the data quality information from the risk management section to see how the physician is going. They can compare any issues that physician has in terms of complications rates as opposed to other providers. I think it definitely is. It's a quality of care issue. It's improvement of patient care.
But they're trying to make a prediction going forward, aren't they? I mean, they're credentialing for the next year, or in this case, the next 2 years.
They're making a prediction going forward, but that is part of the process of peer review. You're looking not only to see what happened in the past, you're looking to see what can we do in terms of the future to try and improve health care. I don't think you can look at peer review as a past only. It's really it looks forward. It has to. If you want to improve quality of care, you look at what's happened to try and predict what you might do in the future in order to prevent something from happening.
If it is correct, and I'm sure it is correct, that 205 was enacted within days of Beth Israel, would it be fair to conclude that the legislature simply wasn't thinking about the disciplinary side of the board?
Well, they mentioned it, though.
They do. They mention it in that one particular section, but as I said, they've already said for the disciplinary board, you have to have, for the disciplinary unit under Beth Israel, under the Choate case, you have to have that 30A proceeding started in order to get the materials. But I think also the point I would like to make is if you look at the credentialing as done at Hallmark, it seems quite clear it's Section 204 material. It's all done through medical staff committees which have been deemed as peer review. It's somewhat your old-fashioned 204 peer review that was in effect before 205 was enacted. It goes, and it's everything, as we've demonstrated through the affidavits and through the testimony of Dr. Summerer, is done in conjunction with everything is done
So
by,
even
for,
the
or as
board's
the peer review.
materials, they can't get back, you would say?
Actually, there's I'm sorry.
I mean, isn't one of the things that's included is materials that were from the board itself?
There is actually a footnote in Carr on that point. You can access, if a peer review committee utilizes material from an outside source, you can get that material from the outside source, but not from the peer review committee. So, for instance, the board itself has the application for the particular doctor. If they want information on malpractice information, they can ask the insurers. They know who insures the particular individual because it's on the application to the Board of Registration in Medicine. They know where the individual has practiced. They can get information from the hospital at which the person has practiced, or at least from the providers there. But I think it's fairly clear that this is also completely Section 204 materials.
So you're saying 204 and 205 are identical?
I'm saying 205 before it's materials necessary to the work product. The same protections as under 204.
So then if you're wrong and we give meaning to the proviso that you don't think we should, then we interpret 205 to be the legislative intention to overrule Beth Israel and to grant access to even 204 material that's greater than we said is allowable in Beth Israel.
No, I don't think that would be true, Your Honor. I think it's affording the same materials to, the same privilege to materials that even before Beth Israel apparently were of concern to the legislature, just based on legislative history and enactments.
From disclosure to the public.
From also disclosure, Your Honor, to the Board of Registration, at least through the Enforcement Division, until such time as they get the 30A.
I thought you were making actually a somewhat just a different point, which is, yes, 204 and 205 go together, but even if they don't, in this case, I thought that's what you're saying. In this case, what it is that's included in the privilege log is pure 204.
I'm saying it's pure 204 because
So
if
that
you-
even if 205 didn't exist, it would be,
It's pure 204, because if you go through the Hallmark credentialing policy, you will see, which is how I did the privilege logs, my privilege logs matched up not only to the Board of Registration in Medicine regulation under its quality assurance program on credentialing, which is about 243 CMR 3.05, but also matched it to the Hallmark credentialing procedure, and the two actually dovetail quite neatly.
Did the judge below make such a ruling that what exists in this case is pure 204?
He did note, Your Honor, that there was the virtual match-up of the Hallmark credentialing policy through the medical staff peer reviews to the board's 243, 205 requirements. It seemed to me he found it, given 205 references 204, he found there was a 204 protection for the materials.
Thank you, Ms. Eldridge.
Thank you.
SJC-10317, Commonwealth versus Cabral.